You want an attorney to explain all of your rights as well as your obligations.
What should you do if you've been denied workers' comp? We're going to talk to attorney Michelle Martin about that on today's Ask the Lawyer. Michelle, thanks for joining us.
Hey, Molly, thanks.
Nice to see you. Are all workers' comp claims approved? Are there legitimate reasons why a person might have a workers' comp claim denied?
Great question. All workers' comp claims are not approved. That's typically why attorneys get involved or how attorneys get involved. There are some workers' comp claims that may not fit the qualifiers for the workers' compensation. So as a result, they will be denied. Workers' compensation is very form heavy. So if you're not able to fit the categories properly, then you will have a claim that is denied.
So for those denied claims, if the claimant had done something differently, could there have been a different outcome? And are most of these situations one where the person didn't have a lawyer?
It really just depends on the type of injury and the way in which the incident occurs. The type of injury sometimes is not the natural injury that may result from the type of incident that may have happened. Additionally, there may be incidences that occur outside of the scope of employment that may put it outside of workers' compensation. And those two things combined can easily make a workers' compensation claim denied. At that point, you really do need an attorney. And it's really smart to get an attorney involved early on so that you don't do anything to compromise your claim.
Absolutely. Can a person appeal a denied workers' comp claim? And what is that process like? And do you need an attorney for that?
So yes, you can appeal a denied workers' comp claim, and you absolutely should appeal the workers' comp claim. You need to preserve your right to appeal it later on, and you should get an attorney. It's not mandatory that you get an attorney to file an appeal, but you should definitely get a knowledgeable attorney who is very savvy as it relates to the rules in workers' compensation and the process therein.
Can you explain a little bit about what that process of of appealing a denied workers' comp claim is like?
Sure. Again, workers' compensation is very form heavy. So once the claimant or the injured worker receives the actual denial, that denial then would have the information for requesting a hearing, which would give you an opportunity to place the commission on notice that you do appeal their decision or the Bureau's decision to deny your claim. At that point, you would get a hearing and an opportunity to present any evidence that you had as to why that claim should not be denied. Once you're at that hearing, the employer would also have an opportunity or a representative to be present to represent their interests and discuss why the employer decided to deny that claim. And so at that point in time, it'd be up to the commission to decide whether or not the injured worker or the employer should win or prevail. Is what I was going with that. Prevail at that hearing level, and so that's kind of the process for the appeal.
And what are the chances of winning an appeal? And what can somebody do to increase their chances of winning that appeal?
It's been my experience that the commission is very injured worker friendly. And so as a result, the chances of winning the appeal, the chances for success are very high. So definitely follow every instruction by your medical provider. The very first thing, of course, would be to get if you're injured, you want to go get your diagnosis and file the proper first report of injury with the Bureau so that they have a record of your injury and that they're aware of any steps that would need to be taken next. The next step would be to get a knowledgeable attorney so that any type of treatment that you need and any types of claims or forms that need to be filed are properly filed in a timely manner. A lot of the times, the Bureau will have their own doctors that you need to go and see, and you need to know how to actually get in contact with your claim manager, how to properly process all your forms, making sure that you're going to see the employer's doctors and not your own doctors, because sometimes the workers' compensation claim will only allow for payment of specific medical providers. And so you don't want to go against the grain, so to speak, and see your own medical providers. You want to see who's recommended by the bureau.
So, Michelle, even if somebody ultimately wants to make a claim on their own, is it still a good idea to talk to a lawyer?
Absolutely. You want to have an opportunity to explore what the process looks like. You want an attorney to explain all of your rights as well as your obligations. There's nothing like missing a deadline or a date and then the injured worker falling short on their bills or falling behind and saying, well, I should be entitled to this particular compensation. I should be entitled to X, Y, and Z. I've done research, but then being behind on deadlines. So at least go in, meet with an attorney. The attorney should be able to explain to you, given your injury and your employer and a host of other different factors, what to expect throughout the process and whether or not it's even important that you get an attorney at this stage. Sometimes with workers' compensation claims, they're because they can sometimes last a lifetime. There are different stages upon which you'll need an attorney, and I've actually seen workers' compensation cases that have gone through different attorneys depending on the stage of the case. So it's important to definitely get in and see someone early on so that you can get your case started right and the foundation is built correct from the beginning.
And is it worth it to inquire about any other types of claims you might be able to file aside from the workers' comp claim?
Yes, it's very important that you do so, actually. Sometimes there are claims that you may forego because you have not exerted those rights, because you haven't placed those tortfeasors or the other parties on notice of their potential liability. And if you don't do that, then you have sometimes foregone the opportunity to bring those claims by way of missing the statute of limitations, by way of just the person maybe not being within the jurisdiction in which you need to bring the claim. I mean, there are a host of other things. Sometimes you have subrogation rights and liens that need to be explored. And if you don't properly set up those claims, you definitely jeopardize the client's right to recovery. So it's very important to sit down with an attorney who understands, what are all the potential claims that may be available to an injured party and what are all the parties and who are all the parties that are involved.
Michelle, thanks for the valuable information today. Always good to see you.
Of course. Thank you so much.
And that's going to do it for this episode of Ask the Lawyer. My guest has been Michelle Martin. If you want to ask her about your situation, call the number on the screen. Thanks for watching. I'm Molly Hendrickson for Ask the Lawyers.